Can I turn it off now? If I turn the record off? Well, that's it. There you go. I never hold that book.
Where's your audio coming in from? Is that coming from the system? Yeah. Or is that coming from
As 229-00922. We are present here in the open courtroom. Present of the court, the clerk, the court reporter, Mr. Lanz, he's represented by Attorney Jimmy Berry, and the state is represented by Assistant District Attorneys Green and Horowitz. Good morning, everyone. Good morning. Great. So, a couple of procedural matters I do have, which I'd like to give you all copies of the verdict form. So, Madam Clerk, if you could hand that to both the state and the defense so that they can review that for the court. Oh. And we'll have a chance to review, but I just want to give you all a copy to review. You need that copy. Okay, thank you. All right. All right, and yesterday, before we adjourned for the day, the state did rest on their case, and so, Mr. Berry, I will allow the defense to proceed.
Thank you, Judge. I have spoken to Matthew about whether he would wish to testify. His wish to not testify. No, the court didn't want to ask him about that, but at this point, he did not want to testify.
Okay, thank you, Mr. Berry. There are a few questions that I would like to ask Mr. Lanz to inquire about his decision on whether he wants to testify or not. And so, Mr. Lanz, if you raise your right hand for the court, please, sir. Do you swear and affirm that the testimony you will give to this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
No comment.
Okay, can you put your right hand down for me? Mr. Lanz, do you understand that you have the right to testify, and if you want to testify, that no one can prevent you from doing so?
No comment.
Do you understand that no one can make or compel you to testify? That is, do you understand that you have a right to not testify if you do not want to?
No comment.
Do you understand that you and not your lawyer must personally decide whether you will testify or not?
No comment.
Do you understand that if you do not testify, then upon your request, the court will not use your decision against you?
No comment.
Do you understand that if you choose to testify, you will be examined by your counsel and cross-examined by the assistant district attorney?
No comment.
Do you personally want to testify or not?
No comment.
Okay. Attorney Berry, do you stand in your place as an officer of this court, as well as Mr. Lanz's representative, that you have spoken to Mr. Lanz, that you have presented him with the option of whether or not he has the right, or he has the right to testify or not, and all of the issues or concerns with whether he does or does not testify, and also informed him that if he chooses to not testify, then the court will not hold that against him. But if he were to choose to testify, then he would be examined by you as well as the assistant district attorney. Have you spoken with Mr. Lanz and discussed all of this with him?
I have, Judge, and it's his wish not to testify.
All right, thank you. Are there any witnesses that the defense wishes to call?
No, Your Honor.
Okay.
Yes.
All right. Can I have the attorney's approach? All right, before we move into closing arguments, are there any other issues or concerns that we need to deal with?
Just for the record, I think that we would need to go to the directed verdict based on the
Okay. All right. Having heard the evidence that has been presented here, the court is going to deny the directed verdict if there is enough evidence, at least for the court to consider a judgment in each of the counts that have been presented before the court. Right.
I believe this is unnecessary.
Right. So, state, or do you intend to do an open and close, or are you going to waive openings as far as the closing arguments are concerned?
Yes, Your Honor. We will waive the opening and just reserve closing.
Okay. Thank you. Attorney Barrett?
Thank you, Your Honor. Your Honor, I'm not going to belabor too much the evidence, but there are some concerns that the defense has, and I'd like to go over those with the court. And I think it's important to let the court know in the statements that Scott and Teresa Lanz made and the telephone calls that the state through the Celebrate found. I think it's important to know that Mr. Lanz, Scott Lanz, was residing in Washington because he worked there. I think that was brought out. And he had called his son the night before, called Matthew. Matthew indicated that he would be coming home. He did not come home, according to Teresa Lanz. And because of the fact that he didn't come home, like her husband told her that he might.
Sorry, I'm having a little difficulty hearing you, Mr. Bailey.
I'm sorry.
I'm having a little difficulty hearing you.
I'll move this over.
Appreciate it, thank you.
Because of the fact that Matthew did not arrive, she became concerned again calling. And because of the fact that he did not respond, she and her daughter both began to call and were not able to get hold of Matthew. They wanted to make it clear that there was nothing said concerning the fact that she believed that he had committed these crimes. She went there because of the fact that she felt that she needed to do a safety check on him. She hadn't been able to get hold of her. So I wanted to make that clear in the beginning. Let's start with the crime scene. When the officers came to the crime scene, the first thing that they noticed, of course, after Mr. Hicks, the father, had noticed the back window being broken out, the officer came, and I remember seeing on the video that he took his baton and broke out a good bit of the window. There was a lot of jagged pieces still in the window. I questioned him about the area that he would have to climb through. He said, well, I had on a jacket, so I felt it might be unsafe to try to get in without knocking over the glass. I think that becomes important because you can see the size of Matthew. He would have had to step over that area and not be cut from the glass. Didn't attempt to knock out any more of the glass, so it would have been difficult to get in that window without either cutting yourself without breaking some more of the window out. When they got into the residence, the items that were collected were the 3 shell casings. The officers looked for footprints, fingerprints, all manner of trace evidence. None of the trace evidence was found. They didn't find anything that would tie Matthew to being inside that house. As a matter of fact, as the court heard, the shell casings were tested, and there was no DNA of Matthew found on the shell casings. So nothing was found at the scene would tie Matthew to the interior of that scene. As a matter of fact, the only DNA that came off the shells was the child, Jacob's, which we could see that most of those shell casings were probably moved around by him. We saw in the bathroom that the toilet seat was up. There was some toilet paper on the floor, and it appeared to have other items there. When I asked the officer, is it possible that he could have flushed those shells down the toilet, the officer indicated that that might be possible. Shell casings were never found in Athens or any other place. So as far as count 13, I don't think the state has carried their burden on proving that those shell casings were taken from the home. The next area of concern, of course, is the firearm. It does have Matthew's DNA on it. It's a little confusing, the manner in which the gun came to be in the possession of the father. He indicated to the police that the clip for that gun and the gun itself were in the coat pocket, and they did retrieve it, but there was no testimony that I can remember whether there was a clip inside the gun at the time that it was collected. So I'm not sure whether there was a clip ever found in the gun or not, or whether that clip actually fit into the gun. That becomes important because the state wants to try to tie the clip that they found in Athens that had, I think, 5 shells missing. Of course, Matthew in his statement indicated that he had been to the range and fired the gun, but they did not pinpoint exactly when that would have been or where he had gone to the range. They may have been able to find out had they asked that information, whether in fact he had or not. The bullets were the SIG 9mm. When I asked the officer, he said those were very common for 9mm. The next item that we're concerned about is Detective Smith's testimony about the headlight signatures. He indicated this V signature that he saw. Questioned him about the signature. He did not know what kind of vehicle that Matthew Lanz had. He said, I don't know what kind it was. I was only concerned with whether that particular vehicle fit what I saw on the road. So he was not able to testify that all 2008 Lexus would have that same V signature, or whether there's any other vehicles that might have that V signature. Not just that particular. It's not like a fingerprint. It's a V signature from the headlights. But we don't know how many other cars there may be that has that particular type of V. The other area that Detective Smith talked about was the floodlights that he saw coming on and going off. And as he testified, at 9:31, the back floodlights came on. They came on again at 9:55, and again at 10:08. We found through the Celebrex that Ms. Hicks had been on her phone at 9:59, which is about 4 minutes after the back floodlights had come on. We don't know much about those back floodlights because nobody tested to see how long they would stay on or what range they had when they did come on, which is very important because if in fact they are saying that the person went in at 10:08, we don't have anybody coming out after that. If they went in to the house at 9:55, they would have had to have been in the house for 4 minutes in order for the Hicks to use the telephone. So that wouldn't really make a whole lot of sense. So begs the question, did somebody go into the house earlier in the day and was laying in wait for them to get into the house and get comfortable before they made their move? So it's an interesting question, especially the fact that you don't see any corresponding exit floodlights, because any movement either in or out should show. It's interesting also that the car that they are indicating was Matthew's passed by a neighbor down the street at 10:11:32, which is about 1.5 minutes from the 10:08 going into the home, which meant that a person would have to get in, knock the window out, step over a gate, which the gate was up, apparently, because we see that the gate is pushed from the living room back rather than being pushed from where the person came in forward to be able to get to where the shots were fired. So how would a person accomplish that, get back out of the house, get to the car in a minute and a half? It's pretty difficult to be able to do that. We know that there was a lot of glass that was knocked out. We asked about the clothing that Matthew had on. There was no glass shards found in any of his clothing. There was no glass shards found in his vehicle. We don't know whether the shoes that he was wearing was what he was wearing supposedly the night before. We do know that he had to walk a mile or so, maybe 2, to get to the home in Sandy Springs that he was ultimately arrested. We don't know whether he picked up any glass shards on that trip from where he left his car. And we don't know whether these glass shards would match with the glass, double pane glass that was apparently there at the Hicks home. So there was no comparison of the glass shards to see whether or not they might be similar or the same, or whether it was pieces of glass that came out of a car window on the side of the road. So we don't have any other glass shards that had been found. And the state made a point to indicate that he had put his phone on airplane mode to avoid people knowing where he was. That wasn't done until 10:15. Doesn't make much sense if you don't want people to know where you're going, then why not put it on airplane mode when he was going there rather than when he was leaving? Doesn't really make a whole lot of sense. What's concerning too is that if you break one of those panes of glass out, obviously, I asked the officer, it's going to make a lot of noise. They also had a dog that the court heard in the video that went crazy when the officer came in. With the knocking out of the glass and the dog barking and the light coming on, apparently Mr. Hicks didn't have enough time but to stand up, which doesn't make a whole lot of sense either, which might be something to consider, whether somebody could have come into the home at an earlier time and laid in wait. We can simply ask the court to look at all the evidence in the case, and I know the court will, and to evaluate that evidence and testimony, and to render a verdict that speaks the truth. That's all that we can ask. Thank you, Judge.
Thank you, Attorney Berry. Eddie Green, you may proceed with the state's closing arguments.
Your Honor, most Americans these days have iPhones. And one of the reasons that iPhones are so popular is because it has the feature of memories. This is what the memories may have popped up looking like on Amber's phone back in October of 2021. But November 18th of 2021, Tuesday of this past week, 4 years to the day, this is what those memories would look like.
Hey, baby, how are you? Oh, okay, come here. Come here. Hey, come here. Come here. Come here. Hey, how are you? Okay, come here. Come here. Come here. Okay, okay. I don't play with the kid real quick. Yeah, I'll let you. Come here. Come here. Come here. Come here. Come here. Come on.
That was the Hicks' home sweet home. The home that they moved into on September 5th, 2021, believing that they were moving into their dream home. This defendant on November 17th of 2021 shattered those dreams and shattered little Jacob's world forever. This is State of Georgia versus Matthew Lanz. Your Honor, we're here before you with 13 counts of this indictment, each of which we will go through. The defendant was charged with malice murder, felony murder, home invasion, aggravated assault, possession of firearm during commission of a felony, cruelty to children in the second degree, and tampering with evidence. But this case is best told by looking at the timeline. So I want to go back through that timeline, starting on November 17th of 2021. We started this trial on November 17th of 2025, 4 years later. If you go back in time, this is what happened on November 17th of 2021. 7:09 p.m., Justin, Amber, and Jacob arrived home. You remember the testimony that Amber had to send her car to a mechanic shop, that Justin picked Amber up, and that Jacob was with them. At 7:09 p.m., this is the last known footage of the three of them alive together. Unknown to Amber and Justin, their killer was en route. By 5:57 p.m., we know the defendant was driving from Athens to the Marietta area or Athens area. We know that because on his phone, there's a 1 minute and 58-second phone call with his father. And if you remember, his father stated to law enforcement that the defendant called him and was at a gas station heading home on November 17th of 2021. At 9:20 p.m., Lanz drives down Verbena in his 2008 Lexus GS and enters his driveway. And here's the video clip showing as his car drives down the street. We know that's his vehicle because of the headlight comparison or the headlight signature. He then pulls down Verbena and enters his driveway, which is also located on Verbena. Now it's very difficult to see in that region, but you'll see some flashing light ever so subtly in that area that's circled in yellow. And that's when his car is pulling into his driveway. And again, we know this because there was 2 SUVs that followed behind that proceed and pass that camera at 5050 Verbena. We then know not between 9:31 p.m. and 9:32 p.m., Lanz is walking around the rear and side of the Hicks' residence. We can see that the side floodlights illuminate, and then we can see the infrared camera being illuminated as well as he gets close to that side door. We know at 9:32 p.m. he then proceeds back towards his residence. And this is the one camera view that's slightly better, where you actually can see him walking along the roadway back in the direction of his family's home. Between 9:43 and 9:44 p.m., you can again see an individual walking towards the Lanz's property. Now here it's much more difficult to see because of that reflection, but you'll see movement proceed until about this area here, at which point he seems to return back towards his residence. And then at 9:55 p.m., Lanz triggers the side lights again, this time to carry out these executions. You can see movement and shadows reflecting from that light. The floodlights have gone off by 9:59 p.m., indicating that Lanz is now lying in wait in this porch area. But we know that Amber's still alive. We know that at 9:59 and 37 seconds, she loves the comment by her friend, LOL IDKY, but I'm craving it. And she loves the next comment at 9:59 and 40 seconds. Olive Garden it is. At 10:10 p.m., we know that these executions are done. Sometime in that 10-minute window, Lanz executes Amber and Justin, who are completely unaware and defenseless, on their couch in their locked and secured home that they have just purchased 73 days prior. And then he leaves. Just like that. The floodlights come on. He walks towards his residence. and it's over. All with little Jacob alone in his crib. Lanz's vehicle is then captured at 10:11 p.m. As he leaves out Delphinium onto Bells Ferry, and then he drives all the way back to Athens, an almost 2-hour drive. And during that time, he puts his phone in airplane mode. It is not a coincidence that his phone is in airplane mode in approximately the same amount of time it would have taken for him to get back to his apartment in Athens. He puts his phone in airplane mode at 10:16 p.m., and he takes it off of airplane mode at 12:43 a.m. November 18th of 2021, the day after the murder, 9:34 a.m., this is the call it's made.
I want to confirm that you guys have called them on their phone and they didn't answer.
We tried calling multiple times now. My brother's phone rings a few times that we're going to voicemail. My sister-in-law's phone immediately goes to voicemail. According to my mother, they've been off social media for about 12 hours now.
Okay.
That call was placed by Ashley Hicks. They had gone to the residence because it was extremely unusual for Amber to just not show up to work. So unusual that her employer had already called both her father and her father-in-law. Within 10 minutes, police arrive on scene at 9:43 a.m. And of course, immediately upon arriving to the scene, they make entry and they find that Amber and Justin have been executed and they're lying in their blood on the couch. Within 1 hour and 40 minutes of police's initial arrival on scene, before police have even made entry into the home, before police have even confirmed that Amber and Justin are deceased, Scott and Teresa are calling their son. So that 1 hour and 40-minute period is really much shorter, because Scott and Teresa wouldn't have known what the police knew immediately, and they certainly wouldn't have known before police ever even made entry into the home or laid eyes on Amber and Justin. So that 1 hour and 40 minutes is probably closer to an hour, perhaps less. And they're immediately calling their son because they know he did it before any details or any facts have been released to the public. That is their first thought. The neighbors are done, our son must have done it. They knew what happened in this case before any law enforcement ever knew they existed. Teresa Lanz is so concerned that she drives all the way to Athens to lay eyes on her son and confront him about these murders. Keep in mind, it takes almost 2 hours to get to Athens. That first phone call that they make to him is at 11:24 a.m. and within 30 to 45 minutes of that first call, Teresa's already getting in her car. Whatever she had planned for the day, whatever she had going on was not as important as laying eyes on her child, because she knew as a mother, having motherly instinct, that her son committed these murders. She arrives in Athens at 2:14 p.m. We know this because she tells law enforcement she calls when she gets there. She's banging on the door so hard that this defendant thinks that she might actually break the lock off the door or the chain off the door, because she's that upset and that concerned. Teresa goes in the home and she finds the murder weapon. Now, of course, she doesn't know that's the murder weapon initially, but she sees the gun. She sees it by his bedside table on the floor. She described that there was 2 magazines. She said one was in it, well, not really all the way, but it was hanging out of it, and the other one was next to it. That is how the gun was initially found. Next to his bedside table with 2 magazines, one of which was in the gun. And we know from the evidence in this case that the one in the gun would have been the one with only 12 bullets in it. Ultimately, even though the defendant doesn't want to relinquish his firearm to his family, he does, once his dad gets there. His dad that had been in D.C. and traveled all the way home and got picked up by his daughter and drove straight from the airport all the way to Athens to be a part of this conversation. His father took the gun but left behind the magazines, which the defendant then tells law enforcement are inside his desk drawer. November 19th of 2021, 32 hours after these murders, at about 7 a.m., perhaps a little bit earlier, he travels back to Atlanta again. He travels back to Atlanta again. This time, he ditches his car around 5665 New Northside Drive, which is in Sandy Springs. And you can see from the map there that this is just off the highway. I mean, this is just coming off the ramp from 285. Now, ultimately, this dispatch about the burglary comes in at 8:45 a.m., so we know that whenever he leaves the car, it's a little bit earlier than this, which is why it was probably a little bit earlier when he left Athens, probably sometime in the 6 o'clock hour. We also know from when the search warrant was executed on his vehicle that there wasn't really any gas in the car at all. In all likelihood, his car ran out of gas. So was this where he was planning to go? We don't know. Or was it that he was taking 285 from 316 to 85 to 285 to 75 to get back to his residence? Or maybe go look at what's going on at the Hicks' residence. We don't know. But certainly this is on the way back towards Ackworth. But he ran out of gas. So he leaves his car, he cuts through the woods, and he ends up in someone else's home at 90 Cameron Glen Drive in Sandy Springs. And that's when the dispatch call was made for Sandy Springs officers to respond, around 8:45 in the morning. By 6 p.m., with the assistance of Sandy Springs, the dominoes then fall into place. The pieces are then put together, and that is when everyone learns that Matthew Lanz was responsible for these 2 murders. Now, there's 2 checklists that I always like to go through in criminal cases, because it really boils down to 2 things. Number 1, were these crimes committed? And number 2, did the defendant do it? Those are the 2 things we're really looking at. And of course, Your Honor knows better than anyone that the state has to prove each element of each offense beyond a reasonable doubt, and we have to prove beyond a reasonable doubt that this defendant was the one who committed those crimes. So I want to start with the checklist of the crimes themselves, starting with malice murder. Of course, Your Honor knows that the state must prove the defendant caused the death of another person unlawfully and with malice aforethought. Malice aforethought is simply the unlawful intent to kill. So how have we proven malice in this case? How has the state proven that this defendant had an unlawful intent to kill Amber and Justin Hicks? Of course, we can look at both a deliberate intention to unlawfully take the lives of another, and we can look where there's no significant provocation and all of the circumstances show an abandoned and malignant heart. Your Honor, this is so malicious that we have both types of proof. This is implied malice and this is express malice all day long. Executing a couple who is watching TV in the comfort and safety of their own home is as malicious as it gets. If this here isn't malice, then malice doesn't exist. If that is not malice, malice does not exist. Now, while premeditation is not required, we certainly have it here. Lanz arrived at 9:20 p.m. and he executed Amber and Justin at 10 o'clock. 40 minutes thinking, contemplating, stalking. Count 1. Did unlawfully with malice aforethought cause the death of Timothy Hicks, a human being, by shooting Timothy Hicks with a firearm. And count 2, did unlawfully with malice aforethought cause the death of Amber Hicks, a human being, by shooting Amber Hicks with a firearm. The malice is there. This is the timeline showing the malice. He arrives at 9:20 p.m. Between 9:31 and 9:32 p.m., he is creeping around the Hicks's back and side yard. Between 9:43 and 9:44, he is again creeping around the Hicks's residence. At 9:55, he makes entry into their backyard and proceeds to sit there and watch at those Christmas lights, waiting until the time was right in his mind to break the window and immediately execute them so fast that they didn't even have time to respond. By 10:10, he's leaving the Hicks's residence. 10:11, he heads back to Athens. And 10:16 to 12:43, he has his phone in airplane mode. This is proof of malice. He had so much time to think about what he was going to do, and he still did it. You had 3 9mm casings recovered on scene and 2 projectiles. You have 5 total gunshot wounds. These gunshot wounds are consistent with the 2 of them sitting there on the couch, again in the comfort of their own home, watching TV. And when Justin heard that window smash, he got up and started peering around to see who was breaking into his home. And as he's peering around and looking, he gets shot here in his side, and it comes out his stomach and ultimately hits the ground. He then starts coiling as Matthew Lanz is continuing to approach on him. He gets shot in the right arm and then gets shot in the back of the head right here and crumbles because he would have never moved again. He got up to see what was going on, but he didn't even have a chance. Guns all in their home. To defend his baby and to defend his wife, and he didn't even get a chance. And Amber, she certainly didn't get a chance. She still has the blanket tucked under her foot. And you heard the doctor testify that it was consistent with her being crouched like this. The gunshot goes into her forearm, out of her forearm, into her thigh, out of her thigh, and stops at her stomach. And in order to get that headshot, where it has an angle, it has a clear angle, she's probably like this, closing her eyes, not wanting to look. And he just executes her. He shoots both of them in the head. You have 2 projectiles that were found in Justin's body. One from his head, where he had his head turned because he had started to coil, and it stops at the other side of his head. And then one from his chest, because the gunshot wound that went in his right shoulder stopped in the left side of his chest. And you had a projectile in Amber's neck from the shot that went in here and stopped at her neck. He talks about he almost got brainstemmed. Well, he brainstemmed Amber. And I think he wished it worked on him. 5 total projectiles were recovered. We know there were 5 gunshots. He executed them. I mean, he shot them both in their heads in the comfort of their home. And then he kept the gun, he kept the magazine, he kept the rounds, and he just put it in his desk drawer. And was just going to go about his time. He stalked, he waited, he hunted, he drove almost 4 hours total to execute 2 innocent human beings, a mother and a father. That is malice murder. And the state has proven malice murder beyond a reasonable doubt. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. Of course, the underlying felony charges here are home invasion and aggravated assault. For home invasion, as Your Honor knows, the state has to prove the defendant without authority and with the intent to commit a forcible felony therein. Of course, here we're talking about aggravated assault. And while in the possession of a deadly weapon or a firearm, he enters the dwelling house of another while it's occupied by any persons with authority to be present therein. The language of the indictment reads, did unlawfully without authority and with intent to commit the forcible felonies therein, to wit, murder and aggravated assault, while in possession of a firearm, to wit, a handgun, a deadly weapon, enter the dwelling house of another, to wit, the Hicks residence located at 5059 Verbena Drive, Acworth, Georgia, while it was occupied by Timothy Justin Hicks, Amber Hicks, and Jacob Hicks, persons with authority to be present therein. And then the corresponding felony murder count reads, while in the commission of a felony, to wit, home invasion as set forth in count 7 of this indictment, did cause the death of Timothy Hicks, a human being, irrespective of malice. And count 4, while in the commission of a felony, to wit, home invasion as set forth in count 7 of this indictment, did cause the death of Amber Hicks, a human being, irrespective of malice. Your Honor, this is a home invasion. There was forced entry into this home. It was without authority. The defendant was armed with a firearm. We know this because he had a firearm. He killed Justin and Amber with a firearm. He had the intent to commit these forcible felonies of aggravated assault and malice murder because he sat there and thought about it over and over and over until he felt like the time was right. That's exactly what he set out to do. It is exactly what he did do, and then he fled. The state has proven felony murder and home invasion. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. This defendant shot Amber and Justin multiple times using his Zev Technologies OZ9 firearm. That's an aggravated assault. Count 8 reads, did make an assault upon the person of Timothy Hicks with a firearm, a deadly weapon, to it, a handgun. Count 5 is the corresponding felony murder count, while in the commission of a felony, to wit, aggravated assault, as set forth in count 8 of this indictment, did cause the death of Timothy Hicks, a human being, irrespective of malice. Count 9 is the aggravated assault count with respect to Amber Hicks, did make an assault upon the person of Amber Hicks with a firearm, a deadly weapon, to it, a handgun. And the corresponding felony murder count, while in the commission of a felony, to wit, aggravated assault, as set forth in count 9 of this indictment, did cause the death of Amber Hicks, a human being, irrespective of malice. Here is the evidence of the aggravated assault and felony murder. It was his Zev OZ9 firearm, 5 rounds fired into Justin and Amber's body. We have 9 total holes within their bodies. 9 total holes, 5 gunshots, but 9 total holes that this defendant put into their bodies. We've proven aggravated assault and felony murder. Possession of firearm during commission of a felony, as Your Honor knows, the state has to prove the person has on or within arm's reach of his person a firearm during the commission of any crime against or involving the person of another, which is a felony. The way it's charged here, we have murder, aggravated assault, and cruelty to children in the second degree, which are felony crimes. For count 10, did unlawfully have on and within arm's reach of his person a firearm, to it, a handgun during the commission of murder, home invasion, and aggravated assault, felony crimes involving the person of Timothy Hicks. Count 11, did unlawfully have on and within arm's reach of his person a firearm, to it, a handgun during the crimes of murder, home invasion, and aggravated assault, felony crimes involving the person of Amber Hicks. Your Honor, you have the gun in front of you. This is the gun that took the lives of Justin and Amber Hicks. It's his gun. He possessed it. He brought it into their home. He is guilty of possession of firearm during commission of a felony. Cruelty to children in the second degree. The state must prove that the defendant caused cruel or excessive mental or physical pain to a child under 18 through criminal negligence. Criminal negligence is an act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by the act. Executing a mother and father in a home that is filled with baby toys, baby gates, baby locks, a baby monitor right next to his mother's hand and you sit there and you shoot that mother in the head absolutely shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by the act. Any human being knows that slaughtering two parents in a home with a child creates a reckless disregard for the safety of that child. Your Honor, that is common sense. The way the indictment reads on count 12 is that this defendant did, with criminal negligence, cause Jacob Hicks, a child under the age of 18 years, cruel and excessive physical and mental pain by leaving Jacob Hicks's deceased parents inside the home with said child, resulting in the 2-year-old child being alone and unsupervised for approximately 12 hours, during which Jacob Hicks was unable to feed himself, unable to change his diaper, or get the attention of his parents, causing him excessive physical and mental pain. Your Honor, Jacob cuddled with his dead parents. He cuddled with his dead parents. They were dead in his house. He came down the stairs and he crawled in their laps. We know this because there is blood all over his little Mickey Mouse pajamas. It is on the front, it is on the back, it is under the arms of his shirt. It is impossible to get that amount of blood and in those locations without having cuddled and crawled on his parents, desperately trying to get his parents to acknowledge him, not understanding why they wouldn't. He brought his parents toys, trying to get their attention, putting a plane on his daddy's lap, a plane that could not have been there until Jacob came downstairs, bringing his mom a ball, bringing her a monster truck, doing everything he could to get them to wake up and pay attention. Because in a child's eyes, in a 2-year-old's eyes, the world is all about them. And when they wake up in the morning, it's all about them. Let's start the day. The first place any child goes when they wake up is to their mom and dad. That's what Jacob did. And when he couldn't get their attention, he started bringing them toys. He played with the very bullet that robbed him of his mother, that robbed him of his father, because there is no way that that projectile would have landed there but for Jacob picking it up. How do we know this? We know this because we have 5 projectiles. 3 of them were recovered at the medical examiner's office. So 2 of them were left on scene. One of them, if you recall, was right in between Amber's side and her arm, which was likely that bullet that went through her, well, was the bullet that went through her forearm into her thigh and stopped at her stomach. Because that's the only bullet that didn't remain in her body. The other one went into her head and stopped at her neck. Justin had 2 gunshot wounds, both of which the projectile was still in his body and was recovered by the ME's office. The only other projectile was the one that went in his side, out his stomach, and hit the floorboard right next to Jacob's little fire truck that he was driving around the house that morning. He picked it up and he moved it. He played with it. Why? Because it's shiny and it's new and he's never seen this thing in his house. He was literally playing with the bullet that killed his parents. And carrying glass around the house, because you have a massive shard of glass right next to this projectile, a shard that could have not possibly stayed on the defendant's clothes when he broke through the window, but that Jacob would have picked up and played with. Because once again, in a child's eyes, these are new items in the home that any child wants to explore. He didn't have any way to feed himself. He didn't have any water. He had an extremely soiled and sagging diaper that you can see on all the body camera. And again, the most traumatic of all of this is that there's hours of trying but failing to get the love and attention of his parents. Now, we have no way of knowing what time he may have gone downstairs. We don't know if he woke up after hearing those gunshots and came down the stairs and then cuddled up to sleep on the couch with his parents, or whether he didn't come down until the next morning. But what we do know is the very latest possible time that he was awake and downstairs was 6:16 a.m. We know that because Justin's phone activity sensor log that's been presented as evidence. And we know that the timestamps on that are accurate because if you recall, at 7:07 p.m., there's logged activity from Justin's device, and we see him physically getting out of the vehicle at his residence for the last time. We also know because if you look further back in that data that's been tendered as evidence, you see that Justin was extremely active throughout the day. And you heard from Tim Hicks that he was at home on baby duty that day. It was his day off. Thank God he spent his last day with his baby at home. But we know at 6:16 a.m. Jacob is now touching that phone and carrying it around the house. And I highly doubt that when he came downstairs, the first thing he did was take the phone. This was probably after he had been trying to get his parents' attention and failing. And we also know that Jacob took that phone and moved it around the house because ultimately where it was found was on that baby gate, which had been knocked over by the defendant, happened to be right next to his toy ambulance that Jacob also placed there. He even pulled the glasses off his mom and dad's faces, not understanding why they would not respond. Amber's glasses would not have fallen off her face like this, getting shot in the head. It just wouldn't have happened. And we know she was awake because at 9:59 she's loving comments in her girl's text thread. So it's not like she had fallen asleep and somehow they fell off her face. Jacob climbed on his mom and literally took the glasses off of her face to get her attention. 2-year-old children only care about their parents' attention. It's the only thing in the world that really matters to them. And he was so desperate for attention that he climbed on her lap and is touching her face, desperate for her to open her eyes because of what that defendant did. And then when law enforcement comes in the house, there's Jacob, and he now has his daddy's glasses. And you heard from Tim Hicks that he wore glasses when he watched TV at night. And Jacob has pulled the glasses off his daddy's face too. Even the defendant expressed remorse for this. He didn't care about the fact that Justin and Amber were killed. But when it came to Jacob, and when it came to him believing Amber was pregnant as well, he cared. He cared then, and he recognized that that was messed up. He recognized that that's as cruel gets. And that's the only thing he felt bad about. He himself knows that he is guilty of cruelty to children in the second degree. Finally, tampering with evidence, the state must prove that the defendant, with the intent to prevent the apprehension of himself or obstruct the prosecution of himself, he knowingly conceals physical evidence. Count 13 reads as follows: did knowingly conceal physical evidence, to which shell casings, said evidence involving the prosecution of the offenses of murder, home invasion, and aggravated assault, with intent to prevent the apprehension of and obstruct the prosecution of said accused, to which said accused did remove shell casings from the murder scene so as to avoid apprehension and otherwise obstruct the prosecution of himself. These officers tore this house apart. I mean, they tore this house apart. They looked in every single nook and cranny. They moved furniture. They moved the rug. They did everything to locate those casings, and they did. There were 3 casings found, and that was it. Now, why he didn't take the time to get the other ones, maybe he got spooked. Maybe the dog started barking at him. Maybe Jacob came downstairs. We don't know. But he decided he needed to get out of there. So he only took the 2, but he is guilty of tampering with evidence. We don't have to prove what he did with those items. We don't have to prove if he threw them out the window or whatever he did with them. So taking a pause here, are the crimes themselves really in dispute? They're not. They're not. I mean, the crimes occurred. We all agree the crimes occurred. Even the defendant agrees the crimes occurred. He said, somebody murdered them, obviously. And they're like, okay, well, you murdered him, Mr. Lanz. He goes, I don't know what you want me to say. Whether or not he wants to admit he did it, he recognizes that somebody committed all of these crimes. And so the only real issue is, did this defendant do it? We know the crimes occurred. Did this defendant do it? We told you at the beginning, Your Honor, that there were 3 main pieces of evidence we wanted you to consider. That was the digital evidence, the statements, and the forensic evidence. Now, one thing we do not want you to consider regarding his guilt or innocence of these charges is his brother's past behavior, his own past behavior, or his subsequent behavior. And I want to explain that. Your Honor knows better than anyone that you are here to consider the evidence concerning these crimes in this bill of indictment and not past acts or subsequent acts. The only reason that those instances were even mentioned during this trial is because they were inextricably intertwined with this case itself. The only reason we ended up being able to really solve this case when we solved it is because of Sandy Springs. Because when Sandy Springs conducted their investigation and they realized his parents lived right next to the Hicks' residence where there was an open double homicide investigation taking place, they reached out to Cobb County. You heard during the interviews, everything is inextricably intertwined such that you can't even separate the 2. Okay. The only reason that his brother's mentioned is really through the defendant himself. And talking about his brother and talking about the fact that he still thinks that those residents at 5059 were in some way terrorizing him or something along those lines. But we want to make it clear that in no way, shape, or form are we trying to argue propensity or bad character or anything else, because the reality is there is no propensity here. We are not saying there's any form of propensity here at all. These crimes should be considered as an isolated act that happens to be incredibly evil, with the only possible explanation that this defendant provided is those homeowners used to terrorize my brother and there were some demonic lights, which came from this defendant as really the only possible motive, as though he's seeking revenge, although he won't say those words himself. So looking at that timeline, again, we know that it's basically just a 10-minute timeline. We know when Justin, Amber, and Jacob arrived home. We know when the rear floodlights were triggered at 9:55. 4 minutes later, Amber sends her last text ever. The rear floodlights are triggered again, and then the delivery is made. Again, this is the last time. Look at Jacob running in the house, so happy to be home with his mommy and daddy. You have the last 2 text messages, and this is in UTC, the adjusted time, I believe, is on the exhibits there. And then you have the delivery that's made a few minutes later at 10:17 p.m. That's a typo there. But at 10:17 p.m., which we see that notification come through on Justin's watch, which was plugged in his bedside because it was nighttime and they were watching TV. And then that package that was never obtained. So we know that whoever triggered the floodlights at 9:55 and 10:10 committed these murders. We know that because there's no way someone broke in after 10:10 and did not trigger those floodlights. There's no way that when text conversation continues with Amber's friends and she's just not responding, there's no activity. Justin's phone never moves again until 6:16 a.m. We know that whoever triggered those floodlights at 9:55 and 10:10 committed these murders. The defendant's vehicle was on scene during the precise window of the murder. How do we know? Because we see his vehicle drive down Verbena. We see that his vehicle is the only one that doesn't actually continue past 50-50 Verbena, and instead you see some reflection from where his residence is. We have the headlight signature, which is abundantly clear, particularly in the fleeing the scene immediately after these murders. Watch it again, look at that headlight signature. We have the defendant's firearm. This firearm sitting in front of Your Honor, which was purchased by the defendant, absolutely, positively executed Justin and Amber. We know that. The test-fired projectiles from the ATF matched the projectiles recovered on scene not the projectiles, the casings. The test-fired casings matched the casings recovered on scene. All right, Defendant Lanz purchased this firearm 1 month prior. Okay, he had this gun in his possession 1 month prior on October 13th of 2021. And we know it was Matthew Lanz himself who purchased this firearm because they took a copy of his ID. And we have the receipt. He spent almost $2,000 cash buying this gun that he would then execute 2 innocent people with. All of which was unknown to his parents and against their wishes. You heard Scott Lanz, he did not like guns. Not at all. And when they talked about, well, why did you take that gun from him in Athens? Why were you so concerned? He said to police he was going to shoot himself or someone else. That was this defendant's father's concern. His own father admitted that that was the concern, which is why he took the gun from his son on November 18th of 2021. The magazine that held the bullets that pierced Justin and Amber's body was found in the defendant's possession, in which the defendant admitted these were his. One of those, which again is sitting before Your Honor, was missing the precise number of bullets used to carry out these executions. A capacity of 17 bullets in each of these magazines. One of them only had 12, which is the exact number used to kill Justin and Amber. And again, Teresa Lanz admitted that when she first arrived in Athens, that magazine was in the gun. Now, she didn't specify how many bullets were in each magazine, but she specified that one magazine was in the gun and one was lying next to it. The defendant has the exact same type of ammunition that was used to kill Justin and Amber in his possession. And that same type of ammunition was found in the magazines. And you had additional ammunition found in the gun box. The gun box that he had shoved into some bag and then shoved into some storage box. But he also had in his possession. The defendant's DNA was found on the murder weapon. We know this, and that's not a surprise. I mean, Scott Lanz said, yes, my son had that gun. Teresa Lanz said, yes, my son had that gun. They took it from his possession. So it's really not shocking that his DNA is on it. He bought it. We know he possessed it. But he also used it to kill Justin and Amber. Look at his clothing. He had glass in his shoes that were collected from Sandy Springs. And again, why is this Sandy Springs thing important when it comes to the clothing? Well, number one, he had just numerous layers of clothing on. And you have those photographed, pants upon pants upon pants. shirt upon shirt upon shirt, multiple layers. He was never going to cut himself, even if he hit even if he threw himself through that window. He would have never cut himself. Not with the amount of clothing that we know he was wearing 32 hours later. But also important about Sandy Springs is he didn't break glass in that home. There is no broken glass, which makes this shard of glass so important. Had he broken some sort of window or door or lamp or whatever in the home, this would not have been as significant. But there's no glass in Sandy Springs. There's no explanation for why he would have glass shards in his shoes. Another reason that clothing is so important when it comes to Sandy Springs is this lack of GSR evidence. It would have made no difference. Testing his clothes, his hair, his hands, anything would have made no difference because we know he was shot. If he had GSR on his person, on his clothes, on anything, at the point in time that Cobb County learned of him, it would have had zero significance because he had been shot. Which is why it was so important to explain that and explain the sequence of events, to explain this investigation and the findings here. The defendant's cell phone, again, he puts his cell phone into airplane mode as he drove back to Athens. Why? Why do that? Well, the only explanation is because he told his dad, hey dad, I'm coming home. I'm at a gas station. It's 7:57 p.m. and then not showing up. Instead, deciding to execute a mother and father on the couch and then going, I should probably take some steps to cover up. Not only should I take at least the casings I should find, but I should put my phone in airplane mode so they can't get any data off of it. The defendant's statements, he admitted he was on scene that night. That is so, so important. He put himself there. Now, interestingly enough, his timeline that he provides, which is quite precise, is exactly 1 hour off. It's exactly 1 hour off. He says, I got there at 10:30 p.m. and I left at 11:15. Well, no, he got there at 9:20 and left by 10:10. Now, this is November 21st, November 17th of 2021, not long after daylight savings. So I don't know, maybe he hasn't changed his clocks in his car. I don't know. Or maybe he was just being very precise in his timings, but didn't want to give up the fact that he knew exactly when he killed them and needed to adjust his timeline a little bit so it didn't seem like he committed the crime. But either way, it's just so interesting that not only does he put himself there on scene, it's around the right time. And it's for the right amount of time. Because he's ultimately there for 50 minutes. He puts himself there for 45 minutes. Same thing. Now, in his story to police, he says, well, I got so tired when I arrived at my parents' house that I have a key to that I'm just going to drive 2 hours back. I'll take a cat nap in my car for 10 to 15 minutes, then I'll smoke a cigarette, and then I'm just going to drive back because I'm exhausted. I mean, that makes no sense. None whatsoever. He then admitted that there was some sort of bad vibe, which is what caused him to drive all the way back to Athens, never telling his parents he was home, never trying to get in the home, never stepping foot inside his home, and then not wanting to tell his parents he had been there either. I mean, keep in mind, the parents go there immediately, and they're like, what have you done? And he's like, I don't know what you're talking about. I didn't kill anyone. I'm here. I'm in Athens. Right? But then he tells law enforcement, oh, no, I was home for 45 minutes, but I just never went inside. Why lie? When asked, well, if the neighbors were killed, why would they have been killed? He said it probably had something to do with the demonic lights. You heard that interview. You heard the Sandy Springs portion and the Cobb County portion. Because Sandy Springs had already started that conversation. And throughout all of that, he keeps talking about these lights. The flickering lights, the demonic lights. He's fixated on it. And he talks about it over and over. That's the only thing he'll really say as it relates to the Hicks' residence is the lights. Again, the defendant's parents traveled separately an hour and 45 minutes after hearing of Justin and Amber's death. I mean, this was immediate action on the part of his parents, specifically because they wanted to confront him about whether he committed these murders. Scott Lanz said on scene when they went to the Lanz's residence at 600 Delphinium, and they're talking to Scott Lanz outside, right? He tells law enforcement, Teresa called me about what happened here. The first freaking thing for some reason that came to my mind, and then he trails off, and you can't understand the rest of that statement. But you can fill in the blank. Teresa called me about what had happened, and the first freaking thing that came to my mind. That's what this defendant's own father said. And in that same body camera footage, his father says, we tried to have a chat with him, point blank level with us to say, was he involved or was he not? He was very, very, very sketchy. He wouldn't answer. He said, Dad, I didn't murder anybody, but I was not convinced. There was suspicion. His own father did not believe him. During his interview, during Scott Lanz's formal interview with law enforcement, he says if the bullet matches, he's done. Well, the cartridge cases did match. They matched the firearm that Scott Lanz took from him on November 18th of 2021. His parents want to believe that he's sick or mentally ill. You heard his mother say that repeatedly during their interview. Wanting to believe he's insane. And that's reasonable. That is completely reasonable because it is unfathomable to a parent to accept that their child could be so evil. That is unfathomable. But at the end of the day, they still knew what he was capable of and what he did. And Your Honor saw his Google search history. One day before these murders, he is Googling facts about blood and the 10 Commandments. He knows the 10 Commandments. When Detective Jackson asked him about the 9th Commandment, he knows. He had been Googling it not 24 hours before. And on October 29th of 2021, he's Googling, do heads really explode as portrayed in Pulp Fiction? Does 308 explode a human head? And then on October 12th of 2021, he is Googling death statistics, total number of fatalities in the United States 2018, mortality in the United States 2019, fast facts from CDC, death and mortality. This was just one day before he bought this gun. One day. And actually, it was after he had filled out the 4473. But one day before he became in possession of this firearm that he used to execute a mother and father. So how do we know that this defendant committed all of these crimes beyond a reasonable doubt? It's his vehicle, it's his gun, it's his magazine, it's his ammunition, it's his DNA, it's the demonic lights he keeps talking about. His parents assumed he did it right off the bat. The Freudian slip about the North Face. When they're like, you're probably wearing that same jacket you had on in Sandy Springs because there's some light colored top in the surveillance footage. He goes, oh, no, that's my other North Face. A Freudian slip. He admits being on scene. And then during the transport, he says, I still feel terrible about knowing there was a baby in that woman's body. He's like, is that true? Did she really have a baby in her body? Jacob and this unborn child that law enforcement thought existed at the time was the only thing this defendant cared about. The evidence here is overwhelming. Your Honor, the only demonic thing that night was Matthew Scott Lanz. This defendant acted as only a demon would, breaking into a stranger's home to execute them and leave for no reason. We've spent this week talking about the defendant, talking about his actions, his gun, his ammunition, his DNA, his statements, all of this evidence that proves his guilt beyond a reasonable doubt. But I don't want to lose sight of why we are here. And looking at this case from the eyes of Justin and Amber and Jacob. Victims who should be with us today. Victims who should have been able to come to court and tell this court what happened. To tell this court what they experienced and what they felt. But they don't get that opportunity. They don't get that opportunity because this defendant callously and maliciously and cowardly took their lives, but luckily left behind a home that told a story of exactly what Justin and Amber experienced. September 5th, 2021, just one day after Jacob had turned 2, Amber, Justin, and Jacob moved into Amber's dream home. A home that she believed would be their forever home, that they could continue growing their family in. And they were happy. And life was good. And what made this home a home to Justin and Amber was 3 things: safety, security, and love. After all, that is what makes a home and not just a house. Safety, security, and love. And it's why our legislature includes so many protections when you're inside your own home. It is why the phrase sanctity of your own home exists. Because homes are meant to be a sacred place. Amber and Justin had this sign in their dining room: "As for me and my house, we will serve the Lord." A declaration that their home, made up of Amber, Justin, Jacob, and their pets, their dog and their cat, would follow God. Their home was their domestic place of worship, where they would raise their child and nurture him in faith and love and devotion. These are all the efforts they made to protect their home, to protect their place of their sacred place, their domestic church, putting up all these different surveillance cameras and censored floodlights. And it's a shame that they had only been there for 73 days, so they didn't have a chance to start their subscriptions to save all this video footage. But the sad part of all of that is it wouldn't have changed anything. It would have shown that man's face on them. But that's it. That's it, because they wouldn't have had time to act, because he so quickly broke through that window and executed them. But these are all the measures they took to protect their home. And they did everything to protect their child. Baby gate upon baby gate upon baby gate. A monitor, baby locks on every single door. Because they wanted to create a safe place for Jacob to grow and learn and explore. And what safer place exists in this world than one's own home? Those were all of the efforts they took to protect their baby. And they loved inside that home. They loved, and they loved hard. You see it all over that house. You see Bibles. You see in Justin's chair, he had a cushion. There was pictures of him and Amber so happy, and a verse out of Corinthians. You see this love letter that Amber wrote Justin the day before on 11/16 of 2021. I want you to know that you are brilliant. I'm so sorry that this did not work out the way you wanted. I'm confident you will do great next time. Please don't be down on yourself. These things happen. I'm so proud of you. You have to do this for you, not for me, not for Jacob, for you. Remember all the studying, all the quizzes you've had to take. You know this stuff, and you can do this. Find the confidence. There's no reason to be worried or nervous. I have a video for you to watch. Today is cuddle day. Love you so much, wifey. And you look in little Jacob's bookshelf there, and all the books that were in there that you can see based on how they're placed. Oh, the places you'll go, wherever you are, my love will follow. God bless you and good night. These are the books that you can identify from this picture. And I'm sure many of the other ones talk about love and support and raising him in this Christian home filled with love and faith. This was an incredible and perfect family doing everything they could to protect their child, and yet they failed. They failed. And at no fault of their own. As they laid here on this couch for cuddle day, in their dream home, all of their doors locked and secured, the baby monitor on, it wasn't enough. It was not enough. It was not enough to prevent evil that came through that window. Absolutely terrified. Likely frozen in fear, certainly for Amber. Thinking of their sleeping baby who was upstairs and they could do nothing to protect him. Everything they did inside that home was to protect Jacob, and there was nothing they could do. They were unable to go upstairs. They were unable to hug him, grab him, say I love you one last time, shield him from seeing what evil looks like at the age of 2 years old. Nothing. They literally did not stand a chance. And we know, based on Amber's positioning, she died absolutely terrified, which is the worst feeling in the world, particularly when it's in your own home, as she curled up and shut her eyes and looked the other way. And we know that Justin was probably afraid too, and he was thinking of his baby too, but he was the man of the household who was going to get up and see what was going on, but he didn't even have an opportunity to get past the rug because of that man. This is what he left in the home. As though things could not have been worse as is right here where it stops, little Jacob came down the stairs to find his parents. And he found them. And he tried to do what they wish they could have done the night prior. Hug him, love him, lay with him. He got to hug his parents and lay on them and talk to them, but with no response. He tried and he tried and he tried, and he even pulled their glasses off of their faces. The most beautiful faces in the world to him, with absolutely no response. Not his mother's warm, loving body, but a cold, stiff body covered in blood. This was one of the books that you see on his bookshelf. And I don't know if it makes it better or worse to think that this may have been one of the last books that his mom read to him. If someday you're lonely or someday you're sad, just lift up your face, feel the wind in your hair. That's me, my sweet baby. My love is right there. My love will find you wherever you are. It is beyond evil and cruel. So was it even brutal, Mr. Lanz? Was it even brutal? That's what he asked law enforcement. Was it even brutal? Yes, Mr. Lanz, it was as brutal gets. And if you weren't sure that night, you are now. Because you've seen it in the daylight and in excruciating detail, the damage that you caused. And this little boy, now 6 years old, left without a mom and dad. His last memories, if he even has them, is when he was 2 years old. So he's left with pictures. Pictures, many of which are in the home in which his mommy and his daddy was brutally murdered because of this defendant's choices. Choices that he sat and pondered over for 40 minutes. Your Honor, this case is clear. This defendant is guilty of every single count in this indictment. This defendant really doesn't feel bad for what he did. He doesn't. And he knows what he did. He knows exactly what he did. Which is why he feels like none of this is really necessary. But we are asking, Your Honor, to reach a just verdict and a just decision, which is exactly what the defense is asking for as well. But the only just and true decision in this case is that this defendant committed all of these crimes beyond a reasonable doubt. And we ask that you make those findings.
Before I step off for deliberations, I do want to have the state and defense review the evidence that is available to go back with the court for review. If you all would approach for just one moment. All right, I am going to step off for deliberations. The state and the defense will review the evidence that is allowed for the court to take back for review during deliberations. And Madam Clerk will give it to you for handing to Madam Bailiff to bring back once that's done. All right, so at this time we will stand in recess for deliberations.
brief on procedural.
Yes.
Good afternoon. Again, I am Judge Sonia Brown, the presiding judge for the trial of the state of Georgia versus Matthew Scott Lanz, 22-900-922. We are present here in the open courtroom. Present of the court, the clerk, the court reporter, Mr. Lanz. He is represented by Attorney Jimmy Berry, and the state is represented by Assistant District Attorneys Green and Horowitz. In the Superior Court of Cobb County, state of Georgia, the state of Georgia versus Matthew Scott Lanz, defendant, criminal action file number 22-900-922, non-jury judgment after bench trial. Defendant having waived his right to trial by jury, the parties having consented to a bench trial before the court, and the bench trial having commenced at November 17th, 2025 at 9 a.m. Now, therefore, after considering the evidence admitted during the bench trial, the parties' arguments, and the applicable law, the court finds as follows. As to count 1, malice murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 2, malice murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 3, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 4, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 5, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 6, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 7, home invasion, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 8, aggravated assault, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 9, aggravated assault, The court finds the defendant, Matthew Scott Lanz, guilty. As to count 10, possession of firearm during commission of a felony, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 11, possession of firearm during commission of a felony, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 12, cruelty to children in the second degree, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 13, tampering with evidence, the court finds the defendant, Matthew Scott Lanz, guilty. This 20th day of November 2025, signed and affixed with my signature, Judge Sonia N. Brown. Would you all like to take a look at the form?
No, Your Honor.
Right, Madam Clerk, if you would please enter this non-jury judgment after bench trial into the record of the court. Thank you. All right, I will hear from the state and the defense regarding sentencing.
Your Honor, we get talked, I know that the state has quite a large number of people that want to speak. I think it probably would be wise to start that in the morning, so we can get through with it tomorrow.
Okay, state.
We don't have any objection to that. Thank you.
Okay. All right, so we will stand in recess until 10 a.m. tomorrow morning, in which time both the state and the defense will have an opportunity to present arguments and any statements from any victim impact statements or statements in mitigation on behalf of Mr. Lanz.
Thank you, Judge.
Right? We'll stand in recess until 10 a.m. tomorrow morning. Oh, one moment. Oh, 1 moment, please. Court is still in session.
Your Honor, just for the record, and I apologize for not putting this on the record prior, but as for your deliberations, the following exhibits were not provided to Your Honor.
Thank you.
That was State's Exhibit 670, an ATF crime lab report, State's 671, another ATF lab report, State's 917, which was the Google search history, State's 607, which was the ZebTech OZ9 of the defendant's gun. State's Exhibit 468 was not an exhibit. It was never tendered. It wasn't missed. It just was never, that number was never used. Okay. And then finally, of course, we did not provide Your Honor with Master Drive A, which contains State's Exhibits 5, 7, 460, 462, 463, 464, 465, 466, 467, 469, 470, 471, 472, 473, 474, 481, 685, and 686.
Okay.
Thank you.
Attorney Barry?
We agree with that.
Okay. Right, and all the evidence has been brought and placed back in court.
Thank you so much.
All right, we'll stand in recess until 10 a.m. tomorrow morning.
Thank you, Your Honor.
Thank you. Deputies, we do have a status hearing. Well, Floyd, I guess not the fast. I have a status hearing at 1:30 on a separate case. Okay, so we'll be in session at 1:30, but it's on a separate case. Yes, ma'am. Thank you.